Hey everybody, Christine here with Help Solve the Case. Thank you for being here. I am behind the camera, like literally not in front of the camera, but I wanted to come on pretty quickly and talk about the Karmelo Anthony case. We've got some things, just a few things to discuss before we have the two hearings later this week. And because I was a little pressed for time, I asked our AI, my AI assistant, to evaluate the transcripts versus the original motion, the request for a new trial that was entered previously. And I will try to remember to attach to that video. If you did watch it, it was very long. They threw everything plus the kitchen sink in there. And the most interesting part was they were under a timeline. If you'll remember, the new attorneys came in. The trial was not publicized. The transcript was not available. And they kind of had to shoot from the hip as far as getting the motion for the new trial put in place. One of the issues was the public. One of the issues was the deal. And we're going to talk about that. And what the AI is telling me is that what we were told or what they believed, what they assumed at the time may not be accurate. And I think that some of the requests, some of the points that the defense is making will probably fail at the new trial request. And I wanted to go through that very quickly for you. I may not be at the recusal hearing. They're going to ask the original judge to recuse himself. There were statements made to the TV, the issues about the publicity and all that. So they're going to ask for that judge to recuse himself and get the new trial hearing before a different judge because of bias or whatever. And that will happen on the 19th. And then we will have the new trial motion hearing on the 20th. Thank you for being here. I appreciate your liking, subscribing, sharing. If you want to become a member, you can do so. It's 99 cents a month. And everything here is in support of unsolved cases, unidentified human remains, forensic genetic genealogy, and working harder on these investigations. Thank you for being here and thank you for supporting the channel. All right, so what we evaluated here, what AI evaluated was, does the trial record, now that we have it, they released 4 parts of it. I think it was 4 or 5 parts. They released the transcript, and so I had AI run through it really quickly to compare the points. And as I mentioned, we've got some issues here. Okay, so what are we looking at? When the new lawyers filed the motion, they said that the court reporter's record had not been prepared and that they had no way of going over the proceedings because there was no transcript and they were not the lawyers in the case. And I don't even know if any of them were there because of the public access issue. So we got volumes 4 through 8. And this is the AI talking when he says for each ground he's comparing what the motion alleges, what the contemporaneous transcript actually shows, whether the difference matters legally, what still requires testimony at the evidentiary hearing. And important to note is that some of the claims from the motion from the new trial talk about events outside the courtroom, and the transcript can't cover that, right? Because they weren't. The transcript, it's only about what happened in the courtroom that is on the record. Our AI said a preliminary scorecard on the 4 issues. Here's what the rating is. The public trial, ground 1, the AI said it's a 7 out of 10 chance. The AI feels, and this was ChatGPT, that this is the strongest ground, that the transcript does not resolve who was excluded or what happened outside the courtroom, and that the evidentiary hearing matters. When we looked at the motion for the new trial, they referenced several people that had gone to attend the trial. They referenced the jury selection that was televised and people having to leave and then they couldn't come back. And they seem to have a lot of witness accounts. Ground 2 is the agreement and the testimony talking about Karmelo Anthony reportedly was supposed to testify. And there was an agreement. If you think back, if you haven't listened to that video, you may want to watch or listen to that video because it was very distinct about what they would use, what they would reference about what happened under the tent, character assassination, impeachment, things of that nature. And apparently there was an agreement in place. And because of that agreement, Karmelo Anthony was going to testify. And then, according to the new attorneys, that broke down for some specified reasons. And because of that, the AI is rating this 2 of 10 based on what has been revealed in the transcript, again, compared to the pleading, the new trial pleading. And we're going to get into that. Ground 3 is the provocation charge, the intent. Preserved and legally serious, but the trial contains circumstantial evidence the state can use to justify submission. So they were arguing on the provocation charge. And again, we didn't hear any of this. We had no idea of what went on. We just heard what the reporters were talking about, maybe what some of the witnesses heard. We heard nothing. And it sounds like it's a little bit of a different story now that we have the transcript. So the AI rates that 4 of 10. And then the cumulative error, talking about multiple underlying errors. So in order to have cumulative error, cumulative means one after the other, you have to have errors that stack up. And if you only have one, then you will have one. You don't have cumulatives. You don't have more than one. Then that's a 2 out of 10. We're going to talk about each one of these issues. The public trial, and again, this is the AI saying this, his current view, he says this ground deserves factual, and he made these slides, by the way. This ground deserves factual development. The transcript cannot tell us how many people were turned away, how the line was administered, or why the overflow arrangement ended. The overflow arrangement was working during jury selection, but not during the trial, and he bunched all this up. I can't fix it. He says the defense alleges recurring restrictions, limited seats, no continuing overflow room, and no audio-video alternative during the testimony. The defense says trial counsel could not see much of this because it occurred outside the courtroom, and he says that makes an evidentiary hearing important before deciding whether there was a constitutional partial closure because it happened outside the courtroom. And he's got this little snippet here where the court is saying, that's the judge, we are not opening the doors for the audience to leave. If you leave, you are not coming back. That's a good example of that. Okay, ground 2, the agreement plus the right to testify. What the motion says. The new trial motion frames the event this way. The state repudiated the agreement, the defense was trapped, and Anthony was forced off the stand. The motion also says the defense had only about 10 minutes to decide and describes the result as a, quote, 180-degree change in strategy. Now, on the right, we see the motion, this portion right here, 115. Remember, that was a monster of a motion. Here's what they were claiming. Here's that 180 degrees. And they talked about him Karmelo having to make that decision very quickly. Now, the transcript here for ground 2, the testifying the agreement, our AI is telling us that the transcript says something different, and that trial counsel Mike Howard told the judge, quote, that deal ... has held, end quote. Quote, both parties have abided by it, end quote. quote, that deal has not changed, end quote. And here is, looks like part of the record here. But yeah, and I agreed that that deal, for lack of a better term, has held. I believe both parties have abided by it. That deal has not changed. I think Mr. Worski said at the outset of this is, I think the parties had different understandings, but I think that both sides were acting in good faith in interpreting what they believed the other side meant. And that, both of us, I think today, realized that the other wasn't 100% on the same page. I don't know. More on that. No rug pull on the record. Howard, again, trial counsel in the courtroom, went further. Quote, I am not saying ... the state has pulled the rug out from under us. I do not believe that to be the case. End quote. Right here. I do not believe that to be the case. Obviously, we have different understandings and different interpretations of what was said, but and the judge says, we've worked through that. And Mr. Howard says, have worked through that, yes. All right, so I don't know. And then the 10 minutes problem. We heard that that Karmelo only had 10 minutes to make this decision to testify or not testify under the Fifth Amendment right against self-incrimination. Now, our AI looked at the documents and he says the court released Anthony to consult with counsel and his parents at approximately 1:33:56 p.m. And the court returned on the record at 2:05:11 p.m., roughly 31 minutes later. And I don't know if these might be minutes. I'm not sure what this is. I don't see how the time is coming into that. But our AI is telling us 31 minutes later. And so that's not 10 minutes. And again, the new attorneys had to write that whole pleading not knowing what had happened or what didn't happen. Here's, again, ground two. They call it the waiver colloquy. I can never say that word. I can say colloquial, but I cannot say colloquy. When Anthony answers the judge, because just like in Brian Koberger, any type of plea agreement or whatever, the judge usually goes through this large question and answer period to make sure that the defendant or the person making the statement or the agreement understands this. Says the judge did not rely only on counsel. He asked Anthony personally whether he wanted to testify. Anthony says, quote, I don't want to testify. The judge then asked whether he had ample time with his lawyers and family, enough time to make the decision. Anthony says, yes, sir, we did. So there it is. For ground two, the part about the agreement, the gentleman's agreement or whatever the agreement was, they're saying that the hearing could still reveal a broader off-record promise that when they have the hearing, people may testify, there may be statements made about things that were not on the record, recollections, I don't know, emails, like who knows. But the transcript creates problems for the original motion as it was filed because, and this is our AI assessment, Howard said the agreement had held and both parties had complied. Howard said he did not believe the state had pulled the rug out from under the defense. And according to our AI, the timestamps show about 31 minutes of final consultation, and Anthony personally told the judge he had enough time. Our assistant tells us that the transcript does not merely fail to confirm parts of ground two, it affirmatively conflicts with important characterizations in the motion. All right, now we're on to ground three, provoking the difficulty instruction. It says this issue was preserved. Howard objected and argued the state could not satisfy the third element, the intent to provoke an attack as a pretext to inflict harm. Was it self-defense? Was it intentional? Did it meet the statutory elements for the crime? The state answered with circumstantial evidence, quote, touch me, quote, find out statements, hand in backpack, knife evidence, near immediate stabbing after contact, witness impression that Anthony, quote, had a plan. And it talks here about those discussions, about charging the jury. Now, again, with Karmelo Anthony not testifying and with their prior discussion about what they agreed, what they stipulated to about what was going to be said and what was not going to be said, and what they both agreed to not ask the witnesses about for impeachment or otherwise, remember, a lot of stuff allegedly didn't get in. Could still be a problem here. We just don't know. I think the hearing for the new trial will be very interesting to see how they're going to overcome this. And when they had to make the pleading by the deadline and they didn't have the benefit of the transcript, can they amend the facts at the hearing? Or does it make it null and void? If they lose these grounds or these counts and they only have the publicity issue, if our AI's evaluation is right, what happens if they lose on the issues? Is it gone, gone, gone? Or can they do something because they didn't have the transcript to prepare properly and they were just guessing? We don't know. We don't know. We'll have to find out. All right, ground 3. And this is the AI saying that why he still denies it. He says there is a reasonable defense interpretation, meaning, quote, touch me and find out, end quote, with the hand in the bag could be a warning. Don't touch me. Not an intent. He says the question is not whether that is the only interpretation. The question is whether the evidence allowed a rational jury to infer the required provocation intent. So he feels because the record contains the words knife, circumstances, refusal to leave, immediate sequence of contact and stabbing, and witness descriptions of provocation, he thinks the state might have enough. But he still feels it could be a plausible appellate issue. That means to appeal it, but it's definitely below 50-50. So our AI, our assistant, is not sure. Now, ground 4, cumulative error. Cumulative error only becomes powerful if there are multiple underlying errors. And our AI told us, ground 2, weakened by the transcript. Ground 3, preserved, but he feels the judge had enough evidence to submit it. That's the jury instruction. And ground 1 remains unresolved and is the defense's best path. That's the public part of it. If in order to get 4, you need 1 or 2 of these. Here she says, if ground 1 ultimately proves a public trial violation, it may stand on its own. But if 2 and 3, if the judge doesn't uphold or believe in or recognize ground 2 and ground 3, we only have 1 and we need at least 2. That's what he's telling us. So our AI says, would he grant a new trial today? He says no, not on the present record, not what has been submitted in the pleading. He says he would hold the evidentiary hearing, which we have. We have some sort of hearing on the 20th. He feels again that ground 1 is the defense's strongest path because the important facts occurred outside of the reporter's record. So it wouldn't make a difference whether the record was there or the record wasn't there. He says ground 2 is substantially damaged by the information in the transcript. He said ground 3 was legitimately preserved, but he doesn't feel there's enough. to get relief, and relief means new trial. And he said ground 4 adds really nothing unless we can have 2 or more. He says the August 20th hearing matters because witness testimony can still change the analysis, especially on the public access facts and the precise scope of the off-record agreement. We might hear more on that. Maybe family will testify. Maybe, I don't know, I wouldn't think paralegals or people, maybe there's an investigator that's going to show some emails, people that were present at these discussions. We just don't know. So that's where it stands. I wanted to provide that to you because when we did review the request, that's all we had. Nobody had information. Now the transcripts have come out. I am not going to personally go through those, but they are in a repository if you want to go through them on the, I believe, I'm trying to remember what county that is. They are on the site. If you ask me in the notes, if you want to see them, let me know and I could put the link down there. I just can't find them tonight. And we'll see what happens, all right? Again, I don't think I'm going to be there for the recusal, although it might be interesting. Maybe I'll look at it after the fact. But I am going to try to watch for the request for the new trial on the 20th. But again, we've already seen a lack of public access for this. So I don't even know if we will have access to it. All right. Thanks for being here. If you have any questions, put them below. Don't forget, if you're watching this, we're going to be talking about flock on Wednesday. Look at the upcoming live sessions. We've got another live session, and I'm finishing a series on DNA. Very interesting about how the DNA gets deposited, where it comes from, all kinds of amazing ways, and how that can have impact on a case, on the theory, both the prosecution's theory and the defense theory about what happened. And I think it's very applicable to our cases. So I'm going to continue to review that. Thanks for being here. And you'll hear me and probably see me on the next one. I appreciate your support of the channel. Talk to you next time.